Let's start our webinar devoted to administrative law justice in the United States and in the Russian Federation. Now we want
to understand the ground and the sources of administrative law justice and administrative law adjudication in the United States and in Russia. Dear friends, today we have speakers. Thomas Hoyer from the United States of America. He is the administrative law justice, retired administrative law justice, and his friend Jeffrey Bird, who is a retired partner of Arnold & Porter Advocacy, joined him. We have Marina Goltsova here. He is a super professional in human rights protection. She will discuss with us about her experiences with her key topics in Dagestan, in our Republic of Dagestan, when she arguing and will argue tomorrow against local government. As for me, I'm a lawyer and I specialize in administrative law justice because I have PhD in that field. So I will compare all Thomas will say with our legal nature. Okay, let's start. Tom, now it's your turn.
Уважаемые коллеги, U.S. administrative law. The first distinguishing feature, separation of powers. Разделение власти. It's a constitutional principle. Why do we have this principle? Почему у нас есть этот принцип? The answer, to limit the power of the federal government. Ограничить власть федерального правительства. At the end of the 18th century, our 13 colonies had just freed themselves from control of an overly powerful government in England. Therefore, our constitutional drafters wanted as much as possible to minimize the risk that they themselves would then create on this side of the ocean another overly powerful central government. What was their conception? Их мнению, just как или группа людей всегда может попытаться приобрести власть правительства и угнетать население. They were concerned that at any time an ambitious individual or group of individuals might seize undue power in the government and oppress the people. So what was their solution? Противостоять честолюбию честолюбием. Oppose ambition with ambition. According to the separation of powers, it is always in the interest of each branch of government to oppose any attempt by either of the other two branches to increase its authority. That was the solution adopted in the late 18th century in our Constitution, and it has been preserved still to this day. Однако существует у нас одно исключение из этого основа принципа. However, we have an exception to this principle, and it's an enormous, огромное исключение. The exception is our administrative agencies, административные ведомства. Each agency combines legislative and executive and judicial authority. Законодательный, исполнительный и судебный власть. Все в одном ведомстве. Why do we allow this exception? Почему мы допускаем это исключение? The answer, practical necessity. В силу практической необходимости. These agencies appeared in significant number for the first time in the 20th century during the 1930s. At that time, our national economy, this was the era of the Great Depression, Великой депрессии. And the national economy нуждалась в срочной помощи от правительства, first aid, emergency help from the government. However, our traditional governmental institutions lacked the capacity to deal with the situation. Наши традиционные правительственные учреждения просто не в силах справиться с ситуацией. Congress lacked the capacity to enact laws fast enough. Our courts would have been swamped with all the disputes arising from the new rules. The creation of new administrative agencies partly solved the problem. Создание этих новых административных ведомств отчасти решило проблему. Each agency exercised, as I've said, legislative, executive, and judicial authority, all within the one agency. Представляет собой огромное исключение из этого принципа разделения власти. However, really, основная проблема, the basic problem, how then to restrict the authority of these new administrative agencies. Our answer was limit their authority by imposing on them several measures. Единство правия действовать только в четко определенных узких областях их компетентности. They are authorized to act only within the carefully outlined, prescribed sphere of their authority. All of their actions are prescribed in various legislation. Его функции под контролем законом, которые детально предписывают почти всю их функцию. И, наконец, finally, the courts, судьи, the courts of our judicial branch have the final word. Решающие слова on the legalist, на правомочности почти все их действия, on practically all their actions. These measures have so far reasonably, effectively, successfully restrained the authority of all these otherwise potentially overly powerful administrative agencies. Сейчас, может быть, пора сделать перерыв, чтобы все другие могли говорить.
You want me to say a few words?
Yes,
Yeah.
Yes, Jeff, please.
Thank you. Tom summarized the central problem the United States had, and any nation has, in creating a government, and that is how to restrain power. One solution was to divide up power among three branches of government. A second, more recent solution that Tom outlined was to create administrative law judges. There are now in the United States over 1,900 administrative law judges. They have various levels of prestige depending on the agency. Tom, for many decades, served as an administrative law judge at the Environmental Protection Agency, which has the responsibility to monitor and to clean up the environment. The central principle of administrative law judges was their independence. They were given life tenure, they could only be removed for cause, and they had a certain special status within our system. But that status is now under some question, and coincidentally, 10 days before this webinar, the Supreme Court of the United States, our highest judicial body, issued a very important decision in the Lucia case. It dealt with a person who had been convicted in the SEC administrative procedures of fraud. That is, he had been fined several $100,000 for allegations that he committed fraud. He appealed that to the federal courts, and the federal courts determined to take this occasion to look at administrative law judges in general and to discuss their power. And indeed, in a decision of the Supreme Court issued 10 days ago, they decided that the system had to be readjusted and made possibly, we'll see what happens, some very important decisions on this question of their independence. One of the justices of the Supreme Court, to give you a sense of its possible importance, said that it is possible that this new decision, by attacking the independence of administrative law judges, and here I quote, may unravel step by step the foundation of the federal government's administrative adjudicative system, that is Tom's system he described, as it has existed for decades, and perhaps on the merit-based civil service system in general. So it's a very important decision. It may or may not have started a new adjustment, but again, it highlights this question of power and how you separate it and how you control it is very central to the operations of our federal system.
Okay, thank you very
Yes,
much.
may I add that Marita very perceptibly in some pre-webinar correspondence pointed out the extremely far-reaching potential of the Supreme Court decision. So we're going to have to await further developments to see where this goes, because the situation is exactly as Jeff just outlined. It could possibly lead to a major revision of our presently existing arrangements.
And by the way, the gentleman was not convicted. He was just found to have violated the Securities and Exchange Commission. Administrative law judges do not have any criminal power, only civil power.
Согласен ли я с этим решением Верховного суда? Да, этот раз я согласен.
And what will happen afterwards, after this decision?
What will happen now? There will be more lawsuits in the coming years to clarify exactly what are the powers of administrative law judges. And it may take a number of more years to come up with answers to the questions. Congress may hold hearings. It's a very important decision. and it also is tied in to our political situation here in the United States and the question of how much power our current president has and wants.
Okay, thank you. Can the head of an agency annul the decision, any decision of administrative law justice?
The head of the agency. Do you want to answer that, Tom?
Yes, the head of the agency can amend or reverse the decision of the administrative law judge, and the decision of the agency then becomes the decision imposed by the head of the agency. However, and this is the crucial point, the other party may always appeal that decision favorable to the agency, adverse to the other party, may appeal it to a judicial court. And the judges in the judicial court are members of the federal judiciary, a body, an organization, totally separate from the agencies which are in the executive branch. And the final word belongs to the judicial court. And that is the ultimate restraint on any overriding authority of the agency.
I'd like to add one more item. The Supreme Court case we just discussed addressed that issue directly and saying that even though in most cases the agency head can review the decision of the administrative law judge, the practical reality of human life, given we only have a certain amount of time, is that the decisions of administrative law judges, even though they're reviewable by the heads of the agency or the department, are still an exercise of important power, because heads of agencies can't review every decision. These decisions of administrative law judges reflect sometimes weeks, sometimes months of hearings, of evidence, of very complicated proceedings. And their decision, although it's reviewable, is a very important exercise of power. And as a consequence, even though reviewable, so there's some protection, it has an important effect on the parties. And most decisions, even though reviewable, are not reversed. Am I correct? Statistically,
that's overwhelming majority are.
Overwhelming percentage of decisions of administrative law judges, even if they are reviewed, are affirmed.
And one additional point, just to support what Jeff has just said, a crucial element of these administrative law judge hearings, decisions, is that they are hearings on the record. Hearings on the record. What does that mean? It means that the whole proceeding is recorded, word for word, and the administrative law judge's decision is recorded in writing. And for that reason, even if the agency head chooses to reverse it, he has to find some way on the record himself or herself, on paper, to justify his reasons for overturning the decision of the administrative law judge. And that all then becomes part of the material that can be submitted, appealed to a judicial court.
Okay, now it's clear, I think. Can I appeal against an agency in a general court and without appeal to an administrative law judge?
The answer to that question determines on which agency is involved. These agencies, some 30 or more independent agencies, like the Securities Exchange Commission, like the Environmental Protection Agency, each of them was established by a separate piece of legislation. And the rules and regulations governing the appeal procedures from the decisions reached in each agency is generally determined by that individual legislation. So the answer is sometimes yes, sometimes no. one other factor, a real-world factor in this country and in any country is money. It's less expensive to proceed with the administrative tribunal than in a judicial court. So that can be a factor. But as to the legal right, it goes different ways in different agencies. But usually, Dennis, the initial appeal will be made to the administrative agency itself.
Okay. Okay. Thank you very much. And Marina wants to ask you something.
I will try to ask the question. Can you hear me, Dennis?
Yeah.
Okay, that's great. Okay, so I actually have two questions. The first question, it's difficult for me to understand. So there is this other judge, and I'm trying to understand how is it possible that this judge that serves for the agency is essentially independent? Because to me, he's still an officer. And he is, well, we say, in Russia we say, the one who pays can order anything. So I'm trying to understand, because it's paid by the agency, I'm trying to figure out how is it possible that this judge is independent. And the second question, I've heard that Tom had never ever had any decision revoked by the federal court. So I'm wondering why. And the next question coming from this will be, what could be the reasons for the revocation of the decision by the administrative law judge? Thank you.
Your question, Marina, addresses really the most crucial element, perhaps, of the administrative law judge system, specifically how to assure the independence of the judges from agency influence. The way it is done in most agencies is to make the appointment an appointment for life, except only if the judge commits some serious infraction of the law. The agency is without any power to affect the conditions of employment of the judges, cannot increase or reduce the salary of a judge. An important, indeed, vital element of the judge's situation is the process of his or her appointment. In most agencies, the appointment is made initially through processing by a federal government personnel office that is entirely separate from, independent of the agency involved, and a list of qualified candidates is then given to the head of the agency. So up to this point, the agency has had no participation, head of the agency or anybody at the agency, in the selection of the new judge or judges. Agency head gets this list and with his advisors chooses from among this list that has been prepared on the basis of exams and the sort of processing that can be done in any country just to establish judicial qualifications of the candidates. And then the agency head can then select from among the members on that list. And once selected, as I've said, the agency head can't do anything of consequence to affect their situation. Can't increase, reduce their salary, terminate their employment, whatever. However, as I mentioned before, individual agencies are governed by different statutes. The Securities Exchange Commission had a method of appointing judges that was something of an aberration and was certainly more vulnerable to attack. So we'll see whether the significance of this aberration is enlarged in the future treatment, or whether it's maybe just the SEC maybe just ends up changing its method of selecting judges. Just very quickly, as to your question as to why it so happened that my decisions were upheld by the Court of Appeals in Washington, D.C. My basic answer is, published law. There's sometimes no rationally explaining these things, but you just try to do your best in putting down your reasoning on paper.
He's too humble. Because you have to justify the decision based on the written opinions that are set forth. And he's very talented, and you justify the decisions based on the record. And when the courts looked at that record and looked at your written decisions, which can be lengthy, they found that you acted in accordance with the law. There are other administrative law judges that have not such a good record because their opinions don't reconcile with the actual written records of the agency hearings. So it has to do with competence more than luck. And the answer really is, unlike a normal employee in any agency, administrative law judges can only be removed for good cause, and it's rare that they're ever removed. And the kinds of reasons are bribery, maybe gross incompetence, in some cases, rare cases, senility. It's very rare that an administrative law judge has been removed historically. And one of the questions now before the United States is, are we going to change that system? And that's what the recent decision of the Supreme Court suggested might be worthy of examination. Hopefully, it will stay the way it is. At least that's my personal.
Okay, and then I wanted to jump to the second question that I asked before. So, what are the reasons for the to annul, to quash the decision of the administrative law justice of administrative law judge?
What are the grounds to appeal it to the courts?
Yeah.
They're just the adverse decision of the agency to the other party is usually a sufficient ground. If there were enough grounds for the agency to initiate a proceeding against a private party, why any further action by the agency, just for reason of the agency action adversely affecting the private party, that alone is normally sufficient grounds to support the appeal by the private party to a judicial court. That's an important question, but that usually is not a difficult issue for the private party.
And generally, three grounds. One, the decision of the administrative law judge is contrary to the facts of the case. There's just he looked at the facts and he made an erroneous assessment of the facts. Two, it's contrary to the legal standards that have been established by Congress. And three, that there was a serious procedural error by the administrative law judge in the course of the proceedings. For example, he didn't let in relevant evidence when he should have, or he let in evidence that was not relevant or that was sufficiently defective that he made an error, a serious error. And basically, the lawyers in the course of these proceedings are anticipating and trying to find out possible errors under fact and under law.
Yes. However, just to advance one other issue of importance that was covered by Marina's pre-webinar question about the significance of this decision, Supreme Court last week. For decades, in reviewing the decisions of administrative law judges, the Supreme Court has generally said, okay, the administrative law judge and everybody at the agency are specialists in this area: environmental protection, selling of securities, whatever. But we're just generalists, they're specialists. Therefore, we will accord a deference, a special respect to the soundness of their judgment. This deference has been under attack in legal writing, law review articles for several decades. And now people are saying that the decision last week just on the method of appointment of these SEC judges is also going to call into question any further existence of this deference to the expertise of the administrative agencies. So that there's a lot of people at administrative agencies perspiring a lot right now over this prospect.
Dear friends, now we need to finish our webinar because we haven't time anymore and we must go. So I want to thank our distinguished guest. Thank you very much that you are here today. Thank you very much, and I'm sorry for you because I tried to find the sense, the ground, the source, and the nature of administrative law justice, administrative law judge in the United States. But what I decided to myself now, I decided that administrative law judges are neither officials nor judges. So I believe we will stop with it, and that is the ground, and that is the reason to follow, to compare, to continue our webinars, and I believe and promise that the next webinar will be better that we have had today. But I believe that we found the main goal from this webinar. We have understood that we have very different systems. For example, you have administrative law judges in agencies. We have only officials who adjudicate everything. And thank you very much for you work with us. Dear audience, I want to thank you and I want to sorry because yeah, we have technical problems, but I promise that the next time all will be better because we consider our mistakes afterwards, after this webinar. Marina.
And Dennis and Marina, we'd like to thank you very much for the privilege of participating in this web seminar and hearing these presentations. And it was a great honor. And as you see, there's a generational...
Thank you, Jeff, and thank you, Tom, for investing your time. And I believe that when we have comparative seminars, first they are difficult to understand, but then maybe that's my difference with Dennis, but I actually saw a lot of similarities in our system. And that is good because that means that the systems, they work similar and they're supposed to work similar because essentially the idea of any judicial system is to protect the people. So I'm thanking you, Tom, for your time, and I'm thanking you, Jeff, for your time and energy. Thank you very much.
Thank you very much. And